Good evening. You're watching The Digital Age, and my name is James Goodale. The press and the Obama administration reached a deal on the SHIELD law recently. It was called a compromise. Did the press win? Did Obama lose? Did Obama win or the press lose? Tonight, to discuss that question with us is Marty London from Paul Weiss. Thank you for coming by, Marty. And George Freeman, who is Vice President and Assistant General Counsel of the New York Times. I'm sorry, I mumbled through that. What we're going to do now is we're going to show the front page story of the New York Times that reported this event, which was a major event in the media world. There's a story down at the bottom where it says, deal reached in Senate on bill protecting reporters' sources. And then there was a interview, effectively, with the guest on my right, and it starts like this. There was a compromise on both sides, said Paul J. Boyle, Senior Vice President for Public Policy at the Newspaper Association of America. Along with most other major news organizations, the New York Times supports the agreement, said George H. Freeman, Vice President and Assistant General Counsel. Mr. Freeman emphasized that even if the agreement became law, reporters would face a daunting standard to avoid disclosing sources. What do you mean by that?
Well, what we mean is that right now in the federal courts, there's no real protection for journalists when they have a confidential source, when they've gotten a big story that has shown light on government abuse, on corporate malfeasance. The reporters have no protection. And what we're saying here, under this compromise SHIELD law bill, there'll be some degree of protection, but certainly not a guaranteed protection. So it's a daunting test, but at least we'll be in the ballpark to try to convince a judge that our reporter shouldn't give away his confidential source. It should be able to protect that because the story was worth it.
But what, it says compromise. Well, I didn't hear any compromise out of what you just told me.
Sure, there's a huge compromise.
Who compromised with who?
Well, the compromises were that there's some SHIELD law at all, but that the test is still quite rigorous for the reporter to be able to protect his source. So in the end, it's up to the judge to decide under the factors in the law whether the source will be protected or not. Again, that's better than we have now, where we have no federal SHIELD law at all, but it's certainly not a slam dunk in favor of the press either.
Well, compromise means you must have given something up. What did you give up?
What we gave up, particularly in the criminal arena, is that the test is very, very hard. That to protect a source, in addition to the traditional types of tests, which is that the reporter should be the last person you go to before you are forced to reveal a source, and that the information is really critical to the case, there's an additional test, and that test is kind of what is the social utility? Is this worth it from a social, societal, policy standpoint? And the question is the fact that we were able to come up with a story, publish this story, more important than the importance of disclosing who the source is? And on that test, which is a key test and should be really what's vital to determining the answer, we bear the burden of proving that with clear and convincing evidence. So we have to really make a very strong showing that it was worth it. Whether we can do that, only time will tell if this bill becomes law. But that's why I say it was a compromise, because we have some protection, but we're going to have a very, very rigorous standard of proof to show that we deserve that protection. And that's a compromise.
If you were the New York Times, would you agree to this compromise?
Listen, I think that this is a bad bill. I really do. I think if I were the New York Times, I would take anything I could get. I think this is a bad bill. First of all, I think it's totally contrary to the public interest in enforcing the law. The press has done a good job without this bill in terms of all the major scandals that I can think of, Abu Ghraib, Watergate. You can go right down the list. There was no protection. They did a good job. Second, I think the bill is absolutely unconstitutional, and I don't know why the lawyers aren't out there. You know, I carry a little book with me all the time because it's called the Constitution of the United States.
You really carry that with you all the time?
Yeah. Well, for this program I do, and it's got.
Jim was involved in a case where they declared the reporter's privilege was not only constitutional, but was kind of required under the Constitution.
The Supreme Court has not.
How do you twisting that around?
Well, here, let me read to you the 6th Amendment of the Constitution. It says, in all criminal prosecutions, The accused shall enjoy the right to have compulsory process for obtaining witnesses in his favor, unless the witness is a journalist, in which case the defendant is stripped of these Sixth Amendment rights unless a judge thinks that the Sixth Amendment rights should be applied to this witness.
I have to ask him a question.
You see any problem with that?
Did you see lawyers in that paragraph?
Did you
also?
see? And yes, there are lawyers.
We have a privilege for lawyers. We have a privilege for doctors.
Right, and it doesn't say.
Because you're a lawyer, that's important, right?
It doesn't say. Indeed, in the same amendment, it says you have a right to counsel, and it doesn't say unless a judge thinks that for certain defendants you don't get a right. So the Sixth Amendment right is an absolute right. You know, you published a story.
So is the First Amendment.
2 years ago, yes, but the First Amendment is very unclear as to whether you had any rights under the First Amendment, because I heard you say so just now. That's why you like the bill, because up to this point you had, in many courts, nothing when it comes to federal court. Now you have something. The Congress has trying to amend the Constitution of the United States with this bill, and I heard you say that. 2 years ago, you published a story in the New York Times of a case in Brooklyn in which a federal official was on trial for murder in Brooklyn, and the truth was that he didn't do it. A key witness for the prosecution had years earlier told two reporters that he didn't do it. When the defendant tried to get it, the judge quashed the subpoena under the state shield law. And when the witness testified, contrary to what she had on tape, the reporters had a crisis of conscience. And though they had promised her confidentiality, they came forward, told the truth, and the prosecution dismissed the case. So it's a happy ending. It's a very happy ending, but it shows you that if the reporter had in his discretion the right to send this guy to jail or not, because if the reporter had decided not to violate the promise of confidentiality and give up his rights under the shield law, this guy may have gone to the jail for the rest of his life for something he didn't do. Where in the Constitution does a reporter get those rights? Who made the journalist the right to, with a scepter in his hand, said, I pronounce you a confidential source?
Where in the Constitution does the doctor have that right to not be subpoenaed? Where in the Constitution does a psychiatrist have that right? And by the way, those people, and lawyers as well, those people are only helping.
Those rights away? Take them away, George. Don't change the Constitution. That's all I'm saying.
The Constitution's already been changed because doctors have the privilege, lawyers have the privilege. Reporters are having the privilege not to help one person, their client, which is what your attorney privilege is for. They have the advantage and the importance of notifying all of the public as to what's going on.
Listen,
so the privilege
I'm going to get out my violin in a minute. You just said in answer to Jim's question that this was a plus for you. It wasn't as much of a plus as you wanted. It was a plus for you because it at least gave you something where before you had nothing. And I want to know where Congress gets the right to give you something that is contrary to an explicit statement in the Sixth Amendment.
It's not a contrary to this. There are lots of other privileges, as I've demonstrated.
I'll read it to you again.
Let me say one thing.
Tell me if I've read it wrong.
You're saying we had nothing. The fact is,
you said we had nothing. I heard you say it.
There's shield laws in 35 states.
Yes.
This privilege is recognized in 49 of the 50 states.
So why did you want the legislation?
Because that's in the state courts.
So why did you want the legislation?
There's a total lack of uniformity between the state courts and the federal courts.
And there still is.
In the state courts, we've lived with the shield law. We've had the shield law in New York, among other places, which is a much stronger shield law than this federal shield law.
Yes, it is.
And we've not had one politician, not one lawyer, not one district attorney say that we couldn't have gotten the conviction, we couldn't get all our evidence that we needed because of the shield law. It's never happened.
Read the New York Times.
Why is there this great problem?
Read the New York Times. You almost sent this guy to jail.
The Attorney General of New York wrote a brief to the Supreme Court saying the privilege should be recognized. 41 attorney generals have supported this legislation. Why are the main law enforcement officers of every state saying there ought to be a shield law when it's going to be so terrible?
Because they all suck up to the press. Because they're all elected people, and they all have their eye on the editorial page, and they all suck up to the press. The New York Court of Appeals sucks up to the press. The New York politicians suck up to the press, and they.
I only wish.
Well, let me ask.
It's a very powerful institution.
I would like to ask you a question, sir.
Yes, sir.
Does President Obama suck up to the press?
Yeah, of course he does. He gets elected. Why do you think he agreed to this? You know, I hate to say.
I was going to ask you, why did he agree to it?
I hate to say this. It pains me. But if in 8 years I deplored the president of my country, he did one thing right. George Bush refused to agree to any form of this bill. Obama folded. Obama had his constituency and he folded. Happily, he didn't fold very much, because the truth is the press doesn't get nearly as much as they wanted in this bill. The bottom line is that there are many holes in this bill. If you mention the word national security, forget it. They have no protection at all. The bill excludes, you know, I don't want to go into the language, but if you mention the word terrorism or national security, they give it up.
So is that a good thing from your point of view?
Yes. Okay. It's a very good thing. I'm saying that
let me just
the press doesn't get a lot of stuff here.
Let me come back to you and pick up on Marty's comment. The press doesn't get a lot of stuff here, and relate it to Obama. Okay, he says Obama folded, right? But isn't it true that Obama introduced a much stronger shield law bill in the Senate when he was a senator?
He was a sponsor of that, and he supported this legislation during the campaign. So to say that all he did here is support what he had A, sponsored, and B,
I don't disagree with that.
But by the way, let me just say, I mean, if everyone's sucking up, and that's the reason we have this legislation,
right,
how come the press is in the worst financial position it's ever been in history? I mean,
that's because
the sucking up doesn't seem to be working very well.
No, that's because there's all kinds of press out there. See, you think that if it's not printed, it's not press. The press is in problems because of A, the economic problems, and B, because there's all kinds of alternative media that are sucking away their advertising and are sucking away their readers. So the flow of information.
I can't keep track of all the sucking going on.
Well,
the up and the away.
Well, yes, you have to get.
It's like that sucking sound in the last the campaign.
You want to know what the great irony is? The senators who agreed and Obama who agreed to this compromise. Do you know which suppresses in many cases the prosecution's ability to get sources and other information, suppresses the introduction of this information into the public. You know what they call the bill? They call the bill the Free Flow of Information Act of 2009. It's a bill designed to suppress the flow of information.
Why does it suppress information?
Well, it encourages information.
Because when a prosecutor is running a grand jury investigation and he wants to know who blew up the building and he wants to know who murdered the people, and there's a reporter whom he thinks has the answer to that question, and he asks the reporter to come and tell him, so tell me, who is it that confessed to you that he blew up the building? The reporter says, shield law. I don't have to
Just like the lawyer would say that. The lawyer would say the exact same thing, wouldn't he?
Now, let me go back. Can I go back to Obama? Because we've got to sort of make it clear to the audience what's changed.
Yeah.
Okay, so, and they're all interested, as I am, in Obama. I don't understand why Obama comes out with a strong shield law, right? He campaigns on it. I'd forgotten that, actually. And then when he gets in the White House, the first thing he does, which you didn't tell us, is he was against it altogether.
Right.
And then the second thing he does is he enters into this compromise, which took a lot of the rights the press wanted out of the bill. Why did he do that?
He did it because he had pressure, I suppose, from his national security and Department of Justice people who are against this bill. Were against it in the Bush administration, are against it now. Because their only interest is kind of what Marty's talking about. Their only interest is
getting the bad guys.
Right, but there are lots of other interests, like informing our public as to what's going on.
Right.
Let's say the
answer to your question is that when he was a senator, he talked the talk. And now when he's the president, he's got to walk the walk, and it's a whole different perspective. George was absolutely right. He's now responsible for the prosecution of wrongdoers. And if you're responsible for the prosecution of wrongdoers, you don't want to suppress information. that'll help you find and convict the wrongdoers. So it's one thing to stand on the Senate floor and talk about what George does and talk about the great rights of the press, and it's another thing to take a hard look, are we going to find the guilty guy and put him away? Those are two different approaches.
Again, Jim, I got to say, that's not the only issue.
Right.
You know, first of all, it can't be a very important issue if every state law enforcement authority is in favor of this bill. It's only the federal law that somehow needs this addition to make it come into play, come into conformity with what state law has been for the last 20 years.
So what is it, the federal officials are stupid? Only the state officials are smart, the federal officials are stupid?
Secondly, there's another issue in society than getting the 99th degree of evidence against the criminal, and that is informing the public. Cleveland might have no newspapers soon. Do you think that the Cleveland City Council members and the Cleveland mayor and deputy mayors are going to be cleaner or less clean with no supervision, with no monitoring by the press of their activities? And the only way that
doesn't Ohio have a shield law?
The only way newspapers, newspapers are going to be able to monitor whether government is abusing the public, which is what their job is if they can rely on confidential sources. So that the secretary tells the reporter, you know, the mayor is taking money under the table, okay? If the secretary doesn't have confidence that that'll be kept secret, that she's the source, because otherwise she'll get fired, she's not going to say that, okay? And now that concern of having having the minorities, having the non-powerful tell what's going on in corporate America and in government to the press so that the press can perform its role of monitoring the powerful. Without that, the press is nowhere and the public is nowhere, because we have no way of controlling what goes on in government and in big business. That's why this privilege is needed. So that's why the press is needed. Okay?
Let's go back to the beginning of what you said. Are you saying that the reason the newspaper business in Cleveland stinks is because Ohio doesn't have a shield law?
No, I'm not saying that.
So that has the fact that Cleveland's newspapers are in total decline has nothing whatever to do with newspapers.
I'm saying that even you would agree probably that it's not a good thing.
Nothing to do with freedom of the press.
It does. You even would agree that it would be a bad thing if Cleveland had no newspapers. Do you agree with that?
I think it would be a bad thing for any time any business goes out of business. It's bad.
Yeah, but it'd be a bad thing.
If Cleveland doesn't have newspapers, it's because the Cleveland newspapers have not adapted to the change in the media. That's why Cleveland doesn't have any newspapers.
That's not my point. My point is that without newspapers, who's going to look over what government's doing?
Okay,
and the way to look over what government's doing is relying on confidential sources.
No, but that's just false. The fact of the matter is that the press has exposed all of these scandals without the confidential source protection. The Supreme Court
people have gone to jail.
The Supreme Court
as a consequence.
Yes, and well, they should have. And the Supreme Court has said in the Brandsburg case that in terms of what they could see, they saw darn little evidence that the lack of a shield law suppressed in any way people's ability and willingness to tell secrets to the press. That's what the Supreme Court said. You, of course, might know more than they. I don't know.
Okay, now let's take a real live case.
Got it.
And that is the steroids that baseball players were using. It's called Balco, okay?
Right.
Now, what happened in that case was there was a grand jury leak about the Major League Baseball players, many of whom are very famous.
Yes. And
the reporters were threatened with jail for reporting that story because the grand jury was supposed to be confidential. Now, under that circumstance, do you think it's appropriate that reporters go to jail, which they would without this bill, and the bill protects them?
Okay. Before he answers that, let me just point out.
You get to answer all of my questions.
Before he answers that, let me just point out that there's film of George Bush, your hero, shaking hands with the reporters and congratulating them for their good job in this reporting.
Well, look, you know,
all right, come on, let's answer this
George
question,
Bush was not very smart on almost anything he did. So, what happened in the Balco case is the reporters got a grand jury transcript or transcripts from a lawyer.
Right.
The lawyer was violating the law. It is a very important function of the grand jury that provide privacy to its witnesses. The prosecution can't work effectively unless it promises confidentiality in the law to the grand jury witnesses. Therefore, it's against the law to reveal what happened in a grand jury except in certain circumstances. The lawyer violated the law. Now, what's interesting is the lawyer used the reporters. He fed the reporters the stuff. The reporters published it, and then the lawyer made a motion to dismiss his client on the ground that the government had misbehaved by putting the stuff out there. So the judge then said to the reporters, "Where did you get it?" And they said, "Confidential source." Now you have a balance. Is the grand jury interest in the privacy of its witness, in the effective prosecution of criminals, is that less important than, or more important than, the reporter's promise that this promise to hide the fact that a baseball player or many baseball players took steroids, facts that may have come out in the prosecution anyway, because the grand jury was still working. I believe if Balco were to be decided under this case, I'm not sure that those reporters would have gotten off.
Let me
it's a hard balance.
Okay, let's just, for the audience, this is the major change in the law. This is what Marty's talking about. Now there is a balancing. There was no balancing before. The reporters went to jail.
Right.
Marty says even if there is balancing, he'd balance it against the reporters.
I mean, Marty got close this time, but at the end he kind of went off the road.
Right.
And let me explain why.
Okay.
I mean, you're absolutely right, Jim, that under past law, the reporters would go to jail because there's an investigation to find out who leaked it. They're the people who know. It's important. There's no other way of knowing. They're going to go to jail. What this law adds, and Marty seemed to say that it was good that it added that, was a social balancing. Is the interest in grand jury secrecy, which is the law, as Marty says, protecting the grand jury process to be private for whatever reason, but that's our tradition. Is that interest greater or lesser than the interest in the ability of the reporters to report on the story and to A, educate the public as to the dangers of steroids, B, initiate congressional hearings that took place, and C, result in baseball reforming its steroid and drug rules, and E or D, presumably saving some lives of kids in the process who as a result of all that are taking less or no steroids than they used to. It seems to me that the balance is overwhelming in favor of publication because of all the positives that the publication of these stories at the time they were published led to, as opposed to some lawyer thing where, well, we can punish a lawyer for leaking something because under some grand jury rule 6, he shouldn't have leaked it. I think it's easy which way the balance goes there.
Balancing test isn't so bad, is it?
There's an objective appraisal. There's an objective appraisal.
No, but seriously, the balancing approach isn't so bad, is it?
You know what? I'm very reluctant to say that all of our rights and all of our statutes are kind of fuzzy, and we just let the judge decide things. If you have
That's
a right,
what the judge decides things every day.
No, yeah, but there are rules, and what you want to do is, what this statute does is it fuzzies the rules. For example, I agreed with you before where you said when we came into this, before this statute in the federal system, we had nothing. That is to say, when you got a grand jury subpoena, there were many courts who said, you, Mr. Reporter, have no rights at all. You got a grand jury subpoena, give up the evidence. Now you got something. You got a judge who makes some sort of balance. I agree. You have more than you had before, but I don't really believe that the grand jury's ability to find the truth in this circumstance ought to be fuzzied up. Now you do, because it gives you something you didn't have before. You don't recognize that there's no stretch in this rubber band. When you give the reporter a right to obstruct the truth, then you take away from the prosecution the ability to learn that truth.
We
Every
agree.
time you give the reporter one right, you take away from the prosecution or the defendant or the civil plaintiff, you take away his right to
Marty,
learn the truth.
what goes on in the case isn't the only game in town. I just demonstrated that there were all these other positives.
I understand
that
all I'm saying,
resulted.
but you
And
don't
isn't it-
recognize
but isn't
that
it-
you're killing the rest of us, that you're
No,
taking
no, no.
away the rights for the civil plaintiffs, you're taking away the rights of
That's
the
not
prosecutors, you're taking away the rights of defendants who
not
could
true.
go to
There's
jail
plenty of
because
evidence.
the reporter says, well, I granted
There's
confidentiality.
plenty of evidence
Let me
out
ask a
there.
question. Is there anything in this bill that says that the reporter loses his rights if the agreement he made with the confidential source was one that involved a payment of money?
There's nothing about payment of money one way or the other.
So he could pay this guy off and
It doesn't happen. It doesn't happen. I mean, that's...
Okay, guess
Of
what?
course it does. Doesn't happen.
Guess-
So
guess-
speaks the New York Times.
Guess what? We ought to tell the audience that this is just a bill. It'll probably go through in this form if it goes through, but it hasn't gone through yet. And I have to come to the end.
Yes.
The press win or lose? Yes or no?
Metza.
Metza. That's a very good answer. What do you think? Press win or lose?
Well, I think it'll be an advantage to the press, but we have to get through the Senate committee and the Senate, and there are a couple of Republicans who are doing everything they can to stall it. Let's hope that at least it gets a vote on the Senate floor.
Thank you very much
Thank
for
you,
coming
Jim.
by, George Freeman. And thank you for coming by, and come by next week and learn more about the digital age. For the digital age, I am James Goodale. Good night and have a good week.